The regulations made in pursuance of Section 3 of the Act provide that every exercise of a statutory power by a rule-making authority which is of a legislative and not an executive character shall be held to be a statutory rule within that section, but an exercise of a statutory power which is confirmed only by a rule-making authority shall not be held to be a statutory rule within the section. It would therefore seem that, unlike Section 1, Section 3 applies to statutory orders as well as rules, regulations or bylaws, provided that they are made and not merely confirmed by one of the authorities indicated in Section 4 of the Act, but apparently only orders which are made directly under an Act of Parliament by a rule-making authority are considered statutory orders. If a rule or order made in pursuance of an Act of Parliament provides, by way of subdelegation, for the making of further orders, these further orders are not themselves regarded as made under any Act of Parliament, and are therefore altogether outside the scope of the Rules Publication Act. The regulations further provide that a distinction shall be drawn between statutory rules which are general and those which are local and personal, and that the distinction shall follow, unless in exceptional circumstances, that which is adopted between public acts and local and personal acts of Parliament. Statutory rules similar to public general acts are to be printed in extenso in a classified form in the annual volume, and the volume is to have merely a list of the statutory rules which are similar to local and personal acts. To speak broadly, a public act may be described as one which concerns the community as a whole, a local act is one the effect of which is confined to a particular district or locality, and a personal act is one for the benefit of a particular person or particular persons, such as a naturalisation or divorce act. Temporary rules, which have ceased to be enforced at the time of publication of the annual volume, or will so cease a short time afterwards, are not to be included in the volume unless the rule-making authority desire them to be included. The Treasury, with the concurrence of the Lord Chancellor and the Speaker of the House of Commons, may direct the exclusion from publication at length in any annual volume of any rules which it seems to them unnecessary so to publish by reason of their annual or other periodical renewal, and may exempt from Section 3 of the Act and from the regulations any statutory rule or class of statutory rules which may be determined by them to be confidential. The apologists and champions of the new despotism exhibit, indeed, remarkable gifts of inaccuracy. One such writer, in a volume recently published, permitted himself to say generally of statutory delegated legislation, quote, "There is no theoretical limit to which this delegation may be carried, and it has been carried very far in recent years. Usually, Parliament retains some control by the inclusion in the Act of a provision that the rules drawn up by the Executive, in exercise of a power so bestowed upon them by the Legislature, shall be laid before Parliament, in draft, for a certain number of days before becoming operative, and will become operative only in the absence of an address from either House against the draft or any part thereof." End quote. This passage is of course extremely misleading. Such a provision as that which is here described as usual is in fact very rare. It is probably not to be found in as many as 1% of the statutes conferring legislative powers, and in the great majority of such statutes there is no provision for parliamentary control of any sort. In another passage, the public is assured that, quote, "Parliament has also bestowed on ministers very wide powers to make rules and orders covering a multitude of subjects. Generally speaking, they have normally to be submitted to Parliament, either as an essential prerequisite to their validity, or as a precautionary measure after they have come into force." End quote. Here again, the use of the word normally is calculated to give an entirely false impression. The simple truth is, of course, that much the larger number of statutory rules and orders are not required to be submitted to Parliament at all. Elsewhere, inaccuracy takes a different turn. The reader is told that, quote, "In the first place, the very wideness of the language which is used in the statute delegating legislation to an administrative body may in effect oust the jurisdiction of the court. This was so in the powers given by Section 1, subsection 1 of the Defence of the Realm Consolidation Act 1914." End quote. This statement manifestly involves a misreading of the effect of the decision in R v. Halliday, to which reference is made. In that case, it was held that the regulation which was in question was not ultra vires, but the jurisdiction of the court to review the regulation and decide whether it was intra or ultra vires was fully recognised. And in Chester and Bateson, 1920, 1 King's Bench 829, another regulation made under the same statute was held to be ultra vires. Similarly, it is little surprising to read that, quote, "Where the order cannot be made unless both Houses by resolution approve the draft, an appeal to the courts against an order so made would obviously be in the nature of an attempted interference with parliamentary functions, nor would such an appeal be any more effective where an order is laid before both Houses for 21 or 28 days, and can during that period be annulled by a resolution of either House. Negatively, Parliament has approved it. From the point of view of appeal on the ground of ultra vires, therefore, the only class of delegation which gives an appellant a sporting chance is that in which the language of the statute is reasonably restricted in scope, and where submission to Parliament is not required." End quote. The first sentence in this passage ignores the dicta of younger L.J., as he then was, in R v. Electricity Commissioners 1924, 1 King's Bench, at page 212, and the word obviously is therefore not justified, even though it be assumed that the court has no jurisdiction in such a case to quash the order as ultra vires. As for the rest of the passage, there is certainly no authority in support of the views expressed, and they appear to be entirely erroneous. In yet another passage, it is asserted that, quote, the next administrative safeguard is that of public notice of intention to exercise legislative powers. Here the provisions of Section 1 of the Rules Publication Act, 1893, 56 and 57 Victoria c. 66, have wide application. These provisions give ample opportunity for criticism before the rules are made. End quote. In this passage, as is plain, there is no hint of the extremely limited scope of these provisions or of Section 2 of the Act, which makes evasion so absurdly easy. The ample opportunity for criticism exists with regard to comparatively few statutory rules, and in the case of statutory orders does not exist at all. But the variety of inaccuracy is not yet exhausted. In the same volume, the writer asserts that, quote, in contract, whether the private individual proceeds by way of petition of right, or whether he brings into court directly one of those heads of departments of the Crown who have been made more accessible to actions, by statutory provision that they may sue or be sued, he will be met by the array of the Crown's prerogatives in pleading and procedure, viz. Those as to discovery, interrogatories, costs, and the statute of limitations, and so on, which place him at a serious disadvantage. End quote. Here again, the pedestrian fact is that, in such proceedings as those which are referred to, costs are payable as if there were an action between subject and subject, the prerogative of the Crown in this respect having been abolished. The statute of limitations cannot be pleaded by the Crown in answer to a petition of right, but this circumstance is obviously to the advantage of the suppliant. It certainly cannot operate to his disadvantage. With regard to discovery, the plaintiff or suppliant is no doubt at some disadvantage, but even in that respect the disadvantage is, in practice, more imaginary than real. It is not easy to know what is meant by, and so on. But it is in respect of discovery alone that, in such proceedings as are in question, the party suing can be said to be at any sort of disadvantage. Nor, to be fair, is there any real foundation for the statement which follows, that it has long been difficult to bring a successful action against either a government department or even an official for any dereliction of duty, where such dereliction of duty has caused loss or injury to a private individual. As to the practice, referred to in the same context, whereby the government pays damages awarded against a public official for a wrong done in the course of his service, this, again, is obviously to the advantage of the injured party, because he has the certainty, if he is successful, of recovering his damages and costs. Finally, the author, while he says that it is important that effective safeguards should be imposed upon all administrative legislation, repeats in stronger language one of his misleading statements already mentioned, as follows, quote, the large majority of statutes delegating legislative powers merely require that the resulting order shall be laid before Parliament as soon as may be after it has been made, or add that such an order shall be annulled if either House pass a resolution to that effect within 21 or 28 days from the date when the order is first brought before Parliament. End quote. The passage, if it is to be made accurate, must be amended so as to read, a small minority of statutes delegating legislative powers require that the resulting rule or order shall be laid before Parliament as soon as may be after it has been made, and, in rare cases, add that such a rule or order shall be annulled if either House, etc. From these and the like statements, two facts seem clearly to emerge. One is that there is in existence a body of persons who, for some reason or other, are extremely anxious to put the best face upon the encroachments of bureaucracy. The other is that, in the way in which they perform their task, accuracy is not their strong point. Referring to instances in which the statute has been so framed as to provide that rules and orders made under it shall have the same effect as if enacted in the Act, Mr. C.K. Allen, now Professor of Jurisprudence in the University of Oxford, wrote in his well-known work on Law in the Making, published in 1927, that this form of delegation, quote, is more than delegation. It makes the executive not merely a deputy but a plenipotentiary, and it becomes increasingly common. The result can only be confusion in the working of the Constitution and obscurity in the legal conception of the sovereignty of the state. While we have never accepted in full the French doctrine of the separation of powers, it is clear that unless there is some intelligible and consistent demarcation between the different spheres of public law, antagonisms and inconsequences must ensue. It is incompatible with the whole theory of our Constitution that the executive and judicial functions should seriously overlap, but there can be little doubt that the present tendency is not only to invest the executive with judicial powers, but to oust the control of the regular courts and make the executive judge in its own cause. End quote. Nobody is likely to deny that the necessities and emergencies of the Great War afforded a signal opportunity for departmental legislation and produced an enormous expansion in the annual output of rules, orders and regulations, but the encroachments of bureaucracy had begun well before the war, and assuredly they have survived it. During the year 1920, for example, the total output only of those sets of rules and orders which are officially registered was no less than 2,473. The corresponding figure for the year 1927 was 1,349. Does any human being read through this mass of departmental legislation? Is any human brain supposed to have mastered and to retain its contents? During the year 1927, Parliament passed 43 public general acts, and it has been pointed out that 26 out of those 43 acts contemplate or authorise the making of orders in council, rules or regulations. Now, no doubt the common phrase, "everybody is supposed to know the law," is not quite accurate. Mr. Justice Maule put the matter, as was to be expected, with perfect accuracy when he said in Martindale and Faulkner, 2 Common Bench, page 719, quote, "There is no presumption in this country that every person knows the law. It would be contrary to common sense and reason if it were so. The rule is that ignorance of the law shall not excuse a man or relieve him from the consequences of crime or from liability upon a contract." End quote. If the citizen is permitted to be ignorant, his ignorance is not permitted to be an excuse. Meantime, the mass of subsidiary, departmental or delegated legislation, these are different names for the same thing, is manufactured to an extent which passes understanding. The citizen does not know what it is. He does not know where to find it. He probably would not understand it and its relation to the rest of the law if he did find it, but he is bound by it all the same. Everywhere in our statute book, as Mr. Cecil T. Carr writes in his extremely valuable lectures on delegated legislation, the same process is visible. The action of our Acts of Parliament grows more and more dependent upon subsidiary legislation. More than half our modern acts are to this extent incomplete statements of law. If anyone opens at random a recent annual volume of public general statutes, he will not have to turn many pages before finding a provision that His Majesty may make orders in council, or that some public body or officer or department may make rules or regulations, contributing some addition to the substance or the detail or the working of that particular act. End quote. The paradox is that it is precisely in the labyrinth of departmental legislation that the citizen, if time permitted, might find the particular order or prohibition which should direct his conduct, and which, if it be ignored, is ignored at his peril. As a rule, he is not interested in what may be termed the immensities and eternities of legislation or of jurisprudence, but he is, or may be, profoundly interested in the rules or orders subsidiary to a statute, for the very reason that they deal with particulars, and the particular is the thing to be done. It may be hoped that Sir Lyndon Macassey, K.C., is right in saying, in his valuable article upon Law-making by Government Departments, Journal of Comparative Legislation and International Law, Volume 5, Part 1, page 73, that the flood of restrictions and regulations with the force of law that overspread the country during the war opened the eyes of the public to the extent to which liberty may be imperilled by such a system. No safeguard, he says, can possibly provide against the chief inherent objection. Government bills are forced through Parliament under the pressure of the government whips. There is little time for discussion of their provisions, either in the House or in committee. Legislation is passed in the most general terms and left to some government department to apply as it thinks fit under machinery or rules to be made by it. The Cabinet is therefore in a position, through its member at the head of a government department, to embark on a particular policy which has never in any detail been discussed in Parliament or communicated to the public. If the action of the department is challenged in the House, the government can say, as has been done, that the action of the department is fully within the powers conferred upon it by the legislature. Not merely in Great Britain, but in the Dominions there is a rising feeling of hostility to legislation by government departments, except in cases plainly necessary. An interesting example, interesting both in itself and as a specimen of method, may be found under the Public Health Amendment Act 1907. By Section 3, subsection 1 of that Act, the Local Government Board, now the Ministry of Health, may, on the application of a local authority, by order declare any part or section of that Act to be in force in the district of that local authority, and may declare any enactments in any local Act which appear to the Ministry to contain provisions similar to or inconsistent with any such part or section to be no longer in force in that district. By Section 3, subsection 3, any such order may declare any part or any section to be in force, subject to such necessary adaptations as are specified in the order. Section 30, which is in Part 2 of the Act, reads as follows. 30. With respect to the repairing or enclosing of dangerous places, the following provisions shall have effect, namely, subsection 1, if any situation fronting, adjoining, or abutting, or on any street or public footpath, any building, wall, fence, step, structure, or other thing, or any well, excavation, reservoir, pond, stream, dam, or bank, is, for want of sufficient repair, protection, or enclosure dangerous to the persons lawfully using the street or footpath, the local authority may, by notice in writing served upon the owner, require him, within the period specified in the notice and hereinafter in this section referred to as the prescribed period, to repair, remove, protect, or enclose the same, so as to prevent any danger therefrom. Subsection 2. If, after service of the notice on the owner, he shall neglect to comply with the requirements thereof within the prescribed period, the local authority may cause such works as they think proper to be done for effecting such repair, removal, protection, or enclosure, and the expenses thereof shall be payable by the owner, and may be recovered summarily as a civil debt.